the case came out of North Carolina. Ms. McCarthy made a comment that Florida court had always had jurisdiction, and that's inside the transcript. Now, what I want Ms. McCarthy, because she made herself a witness, she testified to that when she said it. When did Monica Smallwood file a application for services in the state of Florida? Because I haven't been able to find that, and my request for production hasn't seemed to have produced that.
Are you calling the attorney as a witness?
The attorney made the statement. I just need anybody. Miss Britt can do it. She's the representative for the Department of Revenue.
I don't think that's something to be testified to. It's in the court record.
Can you please provide it? Since you said it's in the court records, I appreciate that. Can you
Read
please?
the petition. It's under the U.S. Florida Statute 88. That's how jurisdiction is obtained. We went over this the last time.
No, we did not go over that. Is it your position that Miss Smallwood filed that complaint in Florida?
It's,
Okay, so
it was filed through the child support agency, sir. Once again, Florida Statutes 88.
I need the evidence of that petition, because what I do see inside the record is a summons, and what's not attached to that summons is a petition, not the original summons. I find that to be pretty interesting, and I'm aware that Minish and McIntosh was notorious for some unethical behavior, but I'm demanding, not even asking, I'm demanding, because you made the statement now on the record, to show me the original petition filed in the state of Florida on behalf of Ms. Smallwood, because I'm familiar with Rule 12.040 C2, where the representative for the department only represents the department and not the recipient of the services. So I need to see, because she's now made it, and I can give you time if you want to continue this, for Ms. McCarthy to produce that petition, the original complaint and petition that was filed back in 1995, because it's not in the record. And I know Ms. McCarthy would not do anything that would violate the rules of professional conduct.
What do you want from me, sir? You want a continuance?
No, I don't need a continuance. I need Ms. McCarthy to produce the document that she claimed existed in front of me and the whole world.
The department has no obligation to produce a document that's.
And you have no evidence to rely on. Competent substantial evidence will require that you produce it. And if you open your mouth and make an utterance to its existence, I'll calibrate. Oh, you will produce it. So she needs to produce it. It's not in the record.
Okay, go on with your argument, sir, and your facts and your evidence.
Okay, well, it's a fact that it's a fact. I understand that, Mr. Den. Please, let's not try to obstruct my record. It's a fact that the initial complaint was not served within 120 days. It is a fact that the record is void of a initial petition or complaint filed by Monica Smallwood on behalf of Monica Smallwood. Also, the record shows that the state of North Carolina allegedly, some kind of way before you all changed it, filed a petition, filed the amended ERISA petition. It still wasn't served within the 120 days, and it never went back. And interestingly, at the time, Chapter 88, also before they changed the rule, did not allow jurisdiction to be garnered by virtue of the petition by itself. Back in 1997. So just for your edification. Now, I want you to take mandatory judicial notice again of this case, the Con versus Con case, as reversible error to fail to include the child support guidelines worksheet in the final judgment establishing paternity and child support, and that's Department of Revenue Ex Relation RSM versus BJM, and that's 127 SO3D 859, 861. That came out of the second DCS 2013, so it still would be reversible at this point. And by the way, because the filing of a child support guidelines worksheet is mandatory, reversal is required even if the omission is due to the party's failure to comply with the rule. And the 12.285 has been in existence since, I guess, you all the Supreme Court started back in whenever, 75, which is as far back as I could go, is like 90, whatever it was. But anyway, go to the Durham case and go to 850 SO2D at 654. And by the way, Mr. Denton, since you did look at the child support final order, I believe it's like 4 pages, correct? Final judgment.
Yeah, I'm familiar with the order.
Okay, 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 I'm glad you said that. By the way, on the face of the docket, it's evident that service of process didn't happen within 120 days. And an error which appears on the face of the final judgment, of course, is naturally reviewable. But what would make it also necessary is it's reversible and it's actually void. So for 20 some odd years, the Department of Revenue, knowingly and through various attorneys, to include Ms. McCarthy, has maliciously pursued this action without simply looking at the record. And for the record also, I've been arrested some 12 or 13 times on a void order, which is pretty frustrating, to say the least. And despite you all knowing it, and that not just you, Mr. Denton, it's previous hearing officers, Judge Sabella, Judge Ficarota, Judge Ayers, Judge Smith, and I know you all are not this incompetent. I believe you're motivated by something a lot more sinister, but you're not this incompetent. And in the face of these facts, the Department of Revenue, whether it's Ashley Moody, Pam Bondi, even Charlie Crisp, for years have pushed this action. And you've been aware that you had no subject matter jurisdiction. This is going back to when I first had an understanding of what subject matter jurisdiction was. And yet you still refuse to do what the law required. And by the way, there's no parenting plan for Ms. Smallwood either, which would mean that there was no competent substantial evidence by which the department could have based whatever the amount they gave was, because we had no idea what was going. And we know that the Department of Revenue, through an administrative proceeding, can't make a determination on time sharing or custody.